All right, everyone. It's my pleasure to introduce our keynote speaker, Chris Micheli. Chris is the founding partner of Snodgrass and Micheli, a governmental relations and advocacy firm based in Sacramento. As a veteran legislative advocate and attorney, he has decades of experience working on complex issues, policy issues. Over the course of his career, Chris has represented a wide range of clients from nonprofits and public agencies to national trade associations and major corporations. He regularly testifies before committees of the California State Legislature and is widely recognized as an expert on California legislative process and state tax law. Chris is a prolific author and educator. He has written extensively on California government, lobbying, and legislative drafting. In addition, he serves as an adjunct professor at McGeorge School of Law and also teaches legislative drafting at UC Davis School of Law. Please join me in welcoming our keynote speaker, Chris Micheli.
Thank you so much. Good afternoon. Anyone wants pure sugar? Have the pink lemonade. I probably should have stuck with the water. Well, I love, oh, sorry. I know that there are online people, so I'll try to stick here. I prefer to walk around. In class every fall, I hate to sit. I do so much sitting as a lobbyist in my day job. Anyways, it's nice to be with all of you. I'm a self-professed legislative geek. Actually, when my first summer job after my first year of law school was for a firm that, among other areas, did government law and policy work. And so I used to go to the state archives all the time and do research. I was a master at the fiche reading thing. It knew just like how much to spin the knob and all that stuff. And then when they were building the new, at the time, Secretary of State archives, I don't know if anyone ever went out to the temporary one on Douglas Boulevard out in Roseville, Citrus Heights, but I even had to drive out there a handful of times to do it. So, and for my law school case books that I've written over the years, I've also spent a lot of time in my alma mater, McGeorge's law school. So I love being in the library. It's funny, you may or may not appreciate this story, but just finished my 11th year at McGeorge and 5th at UC Davis King Hall, just a half a mile back towards the freeway is King Hall. And we were in the second maybe week of the legislative drafting course, the very first year that we were teaching it. I co-teach it with another colleague, and we were talking about annotated codes and some other stuff for legislative research, of course. And the students were sort of looking at me like they weren't quite sure. And I said, are you familiar with Wesson Deerings? No. Okay. I said, have you guys been to the California law section of King Hall? No. So I immediately said, put your stuff down. We're going on a field trip. It's I guess it's 3 with a basement, but it's mainly 2-story high, and we're in a seminar room on the 2nd floor. So we went down to the first because right behind the entrance, if you go past the reference librarian desk at King Hall Library, you walk right into the California section. And so we went in there, and I pulled Wesson Deering code and showed him all this stuff, and so now we do it every year and show them the daily journals and the histories and other things and how helpful that information is. Of course, all they know is what I affectionately call the Google, everything is research there. So it is what it is. But anyways, I now do that every fall semester when we teach legislative drafting, and sure enough, literally no one has been there before. And it's a little disheartening again for somebody who loves the library. So I've been doing legislative history research for 30 years since I was in law school. And ever since then, I learned from Jenny at Legislative Intent Service that you're doing even a lot of regulatory research, at least their firm is, which is interesting. It's been pretty limited I just haven't been involved in litigation involving regulations, but definitely on legislation. And I'm not telling you anything that you don't know, but it's pretty limited in California, right? And I've tried to explain this to legislators. I've had a lot of discussions, and we haven't done it in like 3 years, but 2 years in a row, I did with a First District Court of Appeal justice in San Francisco for the San Francisco Bar Association. We did a little seminar on mainly statutory interpretation and, you know, what appellate lawyers should know, and from my perspective, and then also from his perspective. And ever since then, I've really thought a lot about this. And I'm going to cover a few of those things today. But, the main thing was the lack of good material that's there. It's not like in DC where you've got like a verbatim transcript of, yes, now due to Prop 54, they have to do audio and visual recording of every committee hearing and floor session. But even then, it's limited if you've watched. I mean, floor session, forget it. They don't talk in detail about it. And a lot of them are, pretty limited in their speeches. They're basically limited to 5-minute presentations anyways, on the floor. So they certainly don't get into much detail. And so unfortunately, we don't have very much there. We also don't have in our committees, like they do at the federal level, markup sessions, right? They already have taken the public testimony and interested parties, and now they're actually walking through the provisions of the legislation. We don't do that, unfortunately, in California. It's very high level. It's mainly, a handful of arguments in support and opposition, maybe some discussion, and that's the extent of it. And so what I've said to a lot of legislators and staff over the years is you don't have much helpful material. And it's not just the fact that we don't have those verbatim transcripts. Even if we did, they would be of limited value, really, in terms of gleaning any insight. Because to me, ascertaining legislative intent broadly is easy in this regard. If we did if we enacted like a new research and development tax credit in the state patterned after the federal one, we already have one, but just by way of example, it's relatively easy. I mean, you're using the tax code to try and incentivize investment in research and development. I mean, that's the intent, right? Where are the disputes? The disputes are primarily, almost exclusively, what qualifies, but sometimes who qualifies. But it's what sort of purchases and payment to employees, qualify for that tax credit. And we provide no insights to that. And I've often said, with the utmost respect for legislative staff at the Capitol here in California, especially those who work for committees, their analyses, I'm sure all of you are very familiar with them, are relatively straightforward. What's existing law? What's the proposed law? And then usually a paragraph for the author's statement, a half a page maybe for the proponents, the opponents, and a handful of committees. We have over 50 between the two houses. A handful of them make, comments. Some they provide additional insights. Sometimes they recommend amendments. And then, of course, they list the supporters and opponents. And that's about it. Why did they choose person instead of taxpayer? Why is this type of equipment eligible but it's silent on this one that somebody's trying to claim. That's where the legal disputes are. And that's where you're trying to ascertain, the judiciary in particular, right? Or even the implementing agency are trying to ascertain what is the intent of the legislature. And we don't have many insights over that. And so I've certainly advocated that they should, describe in those analyses and in their discussion why they're doing certain things with the words of the statute. Instead of, and it's the same thing I found with whether you codify or have uncodified statements of legislative intent or findings and declarations. I always try to say, give some explanation, more detailed explanation of what you're trying to do in the statute. Usually what they have is, broad things like, like for my tax credit for R&D, findings and declarations will be about, California is the home of the tech and biotech industries, and they invest X amount in research and development and employ this number of people. And it's the intent of the legislature to incentivize more research and development and high-paying jobs in California. I mean, does that help anybody? No. And I try to explain like that doesn't, like we all know what you're trying to do in broad strokes, but how helpful is that when you are trying to address an ambiguity in the statute? Or again, why did you choose this over that, or these types of taxpayers could claim it and whatnot? So that's where I've spent some time. The other thing that came out from my those 2 years in a row panels with the judge or justice. Now, the first year he was a judge on the Superior Court in San Francisco, and then he got elevated by Governor Newsom. So I got to call him justice now. Was how the judiciary should respond to statements, declarations of the legislature. And so what I was hoping to chat with you about, which is a much broader discussion than just legislative research and determining an intent, but sharing some of my broader thoughts. I prefer to sort of speak off the cuff, but I put together some materials, so I might end up doing a little bit of reading. But there were three major topics I wanted to talk about, which the first is about the statutory statements. And again, I've already said they've got to be more detailed and extensive, but how they should help guide the courts. I would like to see greater codification of not just intent, but how the court should interpret things, as well as executive branch agencies. And then my favorite topic, especially since I come from the legislative side of things for the most part, is what I've described as a preferred hierarchy of legislative materials that you research and reference. So I think you're all familiar with, we've got four major types of what I'll call, statements in California law, codified or uncodified. Obviously, the uncodified are harder to find. It's funny, for the first time, you may be familiar with a lot of the LegInfo website this year. There is an effort, a Democrat assemblywoman, and a Republican assemblyman who introduced bills this year to allow on the public-facing LegInfo website to get letters that have been submitted. Reason now, under LORA, the Legislative Open Records Act, of course, you can request those. But what's nice is on the portal, they call it, when you upload a letter, it's immediately available to legislators and staff. And the nicest thing is when I first started at the Capitol and then lobbying, was staff would put together binders for committees in the floor session for members. And it would have, of course, the bill, the committee or floor analysis, and then letters of support and opposition. Today, they don't have to carry anything. They have their laptop already there at their assembly or Senate desk. And when they go to like a bill analysis under the support and oppose, if it says like, the California Labor Federation, they just click on it and the letter pops up. But that is unavailable to members of the public. If you're not aware, by the way, the internal LIS system is much more robust, especially in search features, than the publicly available one. And so, again, legislators and staff have immediate access to those letters that have been uploaded to the portal, but the public doesn't. And I have to give some credit to my friends over at Cal Matters because they've been requesting it. They called me a year ago when they embarked on this. They have their digital democracy program, so you can track what legislators say. You can put in a bill and get a lot of information. It'll direct you, and they've got clips then for committee hearings and floor statements about that specific bill and all that, which obviously for more recent legislative history and intent research, it's definitely valuable. They'd like to add more, and so they said, how best can we get this information? And I said, it's going to be difficult, and they'll probably make it as hard as possible. So they've spent the past year trying through whatever means possible to have the rules committee do this, and have unfortunately had no luck. So now some legislators are undertaking the effort. We'll see what ultimately happens with it. But we've got four things: findings and declarations, intent statements, purpose statements, and policy statements are all there. And there's always been a lot of debate, of course, with the judiciary as to how valuable or not valuable those things are. The last piece of my chat with you this afternoon is an offshoot of the Kaufman and Broad case from the Third District Court of Appeal, 20 years ago or so, that sort of delineates between cognizable and non-cognizable legislative history documents, right? And I have some commentary on that momentarily, but the courts have in this state, for good or for bad, I'll criticize them in a little bit, is that they really focus on what is available to the legislature as a whole. Because of course, just like legislators don't really understand statutory interpretation, I don't think that the judiciary respectfully understands the legislative process. I suggested, actually I did it both years, I said I think that legislators should spend a week in the shoes of the judiciary, and judges should spend a week in the shoes of legislators, just to get a sense of what each is going through, because I think it would go a long ways to better understanding statutes and how to interpret them, and of course, how to draft them in a better route. Anyways, so with those statements, I've tried to say, whether we codify them or they're uncodified provisions, that they ought to be given much more credit by the judiciary. But there's also a lot of responsibility, as I mentioned earlier, on the legislature to provide value to those. Again, these generic, highfalutin, 35,000-foot level type of findings and decks, or statements of the policy. It is the policy of the state of California, for example, or the purpose of this law, or this credit, or this statute is X. We need greater specificity and insights to help your work, to help advocates work, etc. So I would love to see more of that going on, because whether you are believe in following the purpose or the text of statutes, this information is valuable. We have a discussion in our legislative drafting class. We could spend an entire semester on statutory interpretation. Obviously, many law schools offer that, but we get into it a little bit because obviously that's very important from a legislative drafting perspective. But one thing that we always say to students, and I think all of them learn it, certainly after the end of the 14-week semester, is you can't draft a perfect statute, number one, that covers every conceivable outcome or something that might occur in the future. And the other thing is we always say, pick 3 or 5 bill drafters and give them the same assignment. And you're obviously going to get 3 or 5 different variations, none of which are wrong and none of which probably are perfect. But we say that to make the point that there is invariably some ambiguity in any statute. And as you know, the California courts have always taken the perspective that, of course, if the language is clear, then we follow the language of the statute. No need to look at any extrinsic aids. If we have ambiguity, then we start looking at this stuff. I debate with myself all the time which school of thought I have, because I know on the one hand, legislators do, let me rephrase that. In concept, legislators and staff draft with a purpose. I think leg counsel attorneys, who I have the utmost respect for, the 85 or so attorneys there, do the best job possible, especially with sometimes difficult clients like elected officials and their staff who think that they know the worst. I will say right now, and we've seen the number of lawyers in the legislature diminish, but the worst are the lawyer legislators because they actually think they can draft language and they really can't. They don't. I mean, no, sir. I mean, other than King Hall, I have to tout the class. I mean, a number of law schools, including my alma mater, McGeorge, have like legislative clinics, and students get some exposure to drafting, but we do it. Our students draft every week for 14 weeks. It's the only class we're aware of in any of the, what are we, like 192 law schools in the US, something like that. Anyways, that's an aside. But I sort of debate, like, shouldn't we, try to figure out always what is like the intent of the legislature? I always remember when I was a young lobbyist, this was an interesting one. It was a penal code amendment, and I worked with knife manufacturers. You see these types of knives that have a hole or a thumb stud in the blade at most stores. Certainly if you go to, Big Five or Walmart or places, fishing, hunting stores, etc., you'll find these. Law enforcement uses them. And the problem is that folks who had possession of them were being arrested for violating the switchblade law, even though they're not like spring loaded or anything. Anyways, I worked over the course of a legislative year with the DA's Association, the sheriffs, the police chiefs, and others, and we came up with basically an exception to carve out these types of knives. And of course, we all thought we had drafted a perfect statute. We had, worked meticulously on every single word, goes through, the governor signs it, good to go. And about a year later, I get a call from SAC public defender who said, I have got this young guy who got arrested for carrying one of these, and he thought it was legal in California. And I said, let me see it. And I said, oh, 100%. This falls under the exemption. And so I went with him to court, and of course the arresting police officer made his argument. And so the public defender, I ended up qualifying as an expert witness, and I said, here's why, and here's what and both the judge and the police officer in the end agreed. And as I walked them through the language, but they said, that's not as clear as you think it was. And it was my first real experience with having, drafted language in a committee hearing room and outside committee room with the legislature, and then realizing it was perfectly clear to all of us who drafted it, but the people who have to apply it, police officers and sheriffs on the street, they were not reading it the way we were. And we went back and redid the language. Ever since then, I also acknowledge, that's why I also say to students, like, you can't craft the perfect statute. And even if you think you did, you still have that implementing agency in the executive branch, or just people on the, law enforcement or taxpayers or whomever it is. So again, this brings me back to why I actually want to see like committee analyses explaining major feature. You can't like do every word in every sentence, but at least addressing the major pieces of legislation and providing it in the committee analysis. Obviously, those are readily available to folks. As you know, since 93 on the LegInfo website, those are all available. And then you can, like main things. What would be main things? Well, again, going back to my tax credit, having fuller discussions as to who qualifies and saying things like, well, we considered extending this tax credit to X, Y, and Z, but chose not to. Especially when they use language like including, includes, but not limited to, includes but not limited to X. Obviously, that's supposed to be a sampling as opposed to means, right? Taxpayer means X, that's it, nothing beyond those words. But as we all know, you can't, again, craft it perfectly. And the debate is, well, is this type of business analogous enough or similar enough to this one that is mentioned here? And that's where the debate is. And so again, I think the greater detail to provide to folks, I think the more valuable those types of statements actually are. I also, to help all of us, whether it's because you're researching it or you're trying to interpret it, is spending some time with perhaps codifying some of these approaches to, interpretation of statutes, which California, it has a few instances of, this statute should be liberally construed to effectuate its purpose, or generic language like that. But there could be other more specific ones. And there's actually a number of states, believe it or not, who do that, including two of my favorite ones. So there's a couple of states that specifically require the courts to ascertain the intent of the legislature. That is a statute in a handful of states. The other one is the requirement to review legislative history. Again, a small minority, but I love the fact that we have that. Obviously, a number of states have plain language or dictionary definition stuff, so why not have those types of provisions in the biggest debate that the justice and I had at the Bar Association events were, his perspective, we know, is it's the role of the judicial branch to interpret. But how do we balance that with the lawmaking power of the legislature? And I said, for example, think about this. In each of the preliminary or general provisions in each of the 29 codes, it says shall is mandatory, may is permissive, singular includes the plural, vice versa, a bunch of other stuff. In almost all of them, it says things like, titles of parts, articles, sections, etc., shall not be determinative, blah, blah, blah. And so the justice, for example, was going through about a dozen different statutory interpretation provisions as enunciated by the California Supreme Court. One of them directly contravenes that legislative pronouncement. So the legislature and the 29 codes say those headings are not to be used for interpreting a statutory provision, are not a negative. And the California Supreme Court said they may be utilized for interpreting. And so we had this discussion about, okay, it is your job to interpret the laws under the Constitution, yes, but what do we do about, what do you do if you're the legislature and you're specifically trying to tell them? And that's why the more valuable I think that those legislative materials are, the more insights that they provide, et cetera, is going to be more helpful. And so that sort of leads me to what I'll call my hierarchy of legislative materials. And over 125 years ago, I hope you don't mind. Like I said, I hate to read, but I put together some stuff. Over 125 years ago, California courts examined legislative intent language in construing state statutes, right? From the early 1900s since then. And what the courts have done, of course, is created what they view as the weighting of these legislative intent materials. And so that brings us, of course, to Kaufman and Broad versus performance plastering. And they have basically said, we want legislative documents to reflect the body as a whole, i.e. the collective judgment of the legislature. And so California courts have repeatedly said they prefer floor or committee analyses, for example, over bill author statements. And I want to differ with that in a couple of instances. First, the legislature as a whole, right, what is presented to them, that assumes a couple of things. And I've had, I used to have in my McGeorge class, the former presiding justice of the 3rd DCA, who was one of the signatories of Kaufman and Broad. And I said, I don't think that decision actually recognizes the legislative process itself. It makes a terrible assumption that all legislators read those materials like the committee analyses and the floor analyses, let alone the bill. By the way, I'll say it here as I always do, that is not a criticism of legislators. At the end of session, they are voting on 300 to 400 bills a day in that final 10 days or so. They don't have the time to read the analyses generally, let alone the bill language itself. So to actually assign them, if you will, or attribute to them all of those statements in floor committee analyses is silly. Yes, they have briefings with their staff. They talk to their colleagues. They talk to lobbyists and others, and they make their own decisions about, is this good policy? Is this good for my district? What are the political optics? Blah, 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 blah. But this notion of, we assign those statements to them because they all read the analyses and that's exactly why they voted for it, or something like that, of course, is not actually the case. The other thing is some of the provisions that they determine are cognizable, for example, aren't even presented. I think the most glaring one is an EBR, an enrolled bill report. If you're not familiar with them, those are done by two entities in the executive branch, the Department of Finance, and it comes from the department up to the agency and then over to the Gov's office. And those are done after the bill has passed the legislature and is pending on the governor's desk. They are confidential communications to the governor. No legislators see them. And they sure as heck aren't even presented prior to them voting on it. And yet, according to the California courts, those are perfectly acceptable to use to ascertain legislative intent. Those that are produced by the executive branch after the vote on the bill. He acknowledged that there are some shortcomings in the Kaufman case, but Anyways, okay, so what are my thoughts? Here are my thoughts on this. I think it's almost going to be the reverse. And I'm happy if you beg to differ with me, but this would be my hierarchy, a ranking of legislative history materials. Codified or uncodified intent statements. And again, I reference back to my earlier comments to you about more detail. Findings and decks, letters to the Daily Journal. Those also need improvement. I'll get to that in a minute. Then floor analyses, then committee analyses, then materials from a bill's sponsor, and then other materials. Why do I like statements by legislators, like in the Daily Journal, and even sponsor statements? Because God forbid those could be biased. That's true. Who are the folks who are most involved in legislation? It's consideration, it's debate. I'll give half of drafting because most of the drafting is done by the attorneys and leg counsel. Legislators and sponsors. Even committee members? No. Members on the floor? Never. No. The people who know the most about the legislative language, what the intent is, why we chose or didn't chose specific language, are those who are most intimately involved in the legislation. That's the bill author and her or his staff. Some of the committee staff, definitely, the ones who analyze it and work on it. And then the sponsors, the people who brought those bill ideas to the legislators. Those are the people most involved. Now, I understand there's some inherent bias and all of that. And yes, the reality is that why Jane Doe authored a bill and is supporting it and, bringing it to law could be vastly different than the reason why Bob Smith voted for it. But in terms of ascertaining intent, what was intended by the enactment of that bill, Jane knows far better than anybody else. Now, again, it's pretty limited what we provide. It's even those letters to the journal. Now, the nice thing about the letters to the journal is they usually are used to address specific items of ambiguity, for example, or that they recognize that there's a shortfall in the language and they're going to, for example, author a bill next year to fix it and things like that. So I think that those letters, albeit pretty limited, are very good indicators of, what was intended or perhaps what not was intended. And so also the letters and all that go into the specifics of legislation from the proponents and opponents, I think is very valuable. And I think they should be given greater credit by the legislature. There is always a lot of discussion. Look, there's plenty of folks who submit letters in support of or opposition that are just generic things, sort of like, again, going back to my original example, a bunch of business groups will send in a letter and say, rah, we need a stronger R&D tax credit. It's good for the economy and blah, blah, blah. And then there will be opponents who say it's a waste of money. It should be better spent on education and health and human services and all of that. That's not helpful for legislative history and intent research, right? But a lot of the folks go through it, especially as the bill goes through the legislative process and says this is who go through provisions of it and say, that there are, here's why we are modifying this language or not modifying this language, for example. Here's why we chose this approach or this language, etc. That's often put forth in those letters from the sponsors. But of course, the judiciary looks at it and says, this is not indicative of the legislature as a whole. Again, I would agree in concept, but they're giving, they're incorrectly assigning, again, intent to the body as a whole when those folks are like, hey, I always vote for things authored by Jane. She's an expert in public safety. Or Bob and I are aligned on how we view local control. So if he's authoring a bill, giving greater power to counties and cities, I'm all in. I'll vote for it. I mean, let's not kid ourselves in terms of how the process, works. And that's why I said I think it would be helpful for the judiciary to go and watch the legislative process, the proverbial sausage making take place. I would hope that it would dissuade them of some of these potential views. And likewise, again, legislators and their staff, I have advocated that judges come over and talk to them about how, for example, they view things and why understanding what the words on the page mean is actually very important. And unfortunately, as part of our legislative process, despite our reduced bill limits, and this year we had the first real impact of it, 550 fewer bills introduced this year than last year, for example. It doesn't mean we're not going to have another 700 new laws this year, but not as many as we're just too much of a bill factory. And so that's why I always say I'm not, despite some of my comments, I'm not actually critical of legislators or staff or committee staff. Why do they do quickie analyses? Here's what the law does. Here's how this bill is going to change it, support and oppose, and on to the next bill. Because they've got 30 bills up in a single Senate Judiciary Committee hearing. They don't have time to provide all the important detail that we're looking for in that legislative history and intent. And again, that's why I come back to my hierarchy in terms of what's the most valuable for, again, ascertaining the intent of the legislature when you're conducting your research. So I'm happy to field questions if people are interested. Otherwise, stuck to my 45 minutes. Yes, ma'am.
Question or two.
Okay.
And I'm from Oregon.
The cap is 3.
Okay. Thank you. I got
Just kidding. Yeah.
I'm from Oregon, so maybe
Okay.
this is local, but
All right.
you mentioned cognizable. What
Yes.
does that mean?
Well, that it is accepted, basically. It's fancy language by the judiciary. It means what are items of legislative history that are accepted by the courts to determine or try to ascertain the intent of the legislature,
So,
the judiciary.
okay. So
And the Kaufman case, so in California, we have, of course, our Supreme Court, and then we have 6 district courts of appeal. This came out of the 3rd district, which is centered in Sacramento. So it's technically not applicable to the other 5, but they've all basically accepted it. And so that actually, they went through. If you read the decision, they actually have in it, like, these are all of the types, and they list everything. Senate Housing Committee. I mean, they don't have to list every committee, but they do. Like here are appellate court decisions in the state of California where this was accepted, where this wasn't, where this was, where this wasn't. So they go through everything from, outside opinions of our AG, opinions of our legislative council, that's our bill drafters, sponsor letters from the author. They go through like every item of legislative history that you can find out there at the time the decision was written. This is okay, this is not okay. This is okay, this is not okay. And that's what that decision
it's like a
says.
manual.
Yeah, it's almost like a manual. Yes. But again, I disagree with a number of it, but that's okay.
You said
It's been cited, the judge said, or the justice said, more than 100, and it's been cited approvingly over 120 times, the Kaufman case. So that's basically the law of the land in the state of California.
okay, and
Yeah.
you said a couple of times, and maybe
Yeah.
everyone knows this, but
Okay.
codified or uncodified
Codified?
provision, you're talking about statutes versus code, or
Oh,
are you
no.
talking about
Our
uncodified
codes are, so we
inside
have,
code?
yeah. So in California, at the federal level, they give them numbers like Title 8, Title 9. In California, our 29 codes are where our statutes are found. It starts with business and professions, ends with welfare and institutions. So streets and highways, health and safety, education, government, penal code. That's where all of our 155,000 statutes are found. If they're codified, it means they're in one of those 29 codes. Uncodified means it's still a statute, but it's not in one of the 29 codes. The best example is the budget. We don't codify our state budget. But there are other things like last year we had an uncodified statute. It named a courthouse after a deceased member of Congress. We don't need that cluttering our codes, but it was enacted just like any other statute. So that's the difference between codified and uncodified. And there's been some debate. The reason why I raised it in this context is what you'll find in our bills before they become statutes is in section 1 of the bill usually is where they're found. And some, they may just be in the bill as enacted, so they're uncodified, or they'll place them in statute, they are codified. There's been some debate between, do you give greater credit to codified or uncodified, like statements of legislative intent or findings and declarations? I went back and forth myself a little bit, but in the end, they're both statutes. Where you find them is irrelevant. They're both statutes. So, and I'm not aware of any court decision that weighed one against the other, but there's been some debate in legislative circles, is one more valuable than another, but I don't think so. Yeah.
I have a question about, I always told my legal research students that the committee report is often the most authoritative source for legislative intent. You're saying that that's not quite accurate, aren't you?
Well, no, in terms of, well, first of all, in terms of Kaufman, yes. My criticism of them, and again, it's not because they're not done well, they have so many bills to do. It doesn't speak, in my mind, they don't speak to, like, again, ambiguity or why we said this versus that. There's no detailed discussion. Look, there's no dispute. There's no legal dispute, or when Franchise Tax Board does an R&D reg, when it has to interpret, implement, or make specific, that's our APA definition of a regulation. When that happens, they know what the intent was. We're trying to incentivize more R&D investment in the state. Okay. But again, why did they limit it to this sort of qualifying activity? Or why is this taxpayer included, but that one not? Does that definition extend to this? Well, if you look at most committee analyses, there's nothing on that. You know, and the regulatory bodies in the executive branch don't have much to go on. So that's my criticism, if you will. But yes, according to Kaufman, those are the most authoritative. And they have greater detail than the floor analyses. Generally today, how does this process work? The committee of first referral, and most bills are referred to as single policy committee, but sometimes it goes to like judiciary and then labor. Judiciary is the committee of original jurisdiction. They're actually responsible for drafting the floor analysis. And all they do is generally cut and paste in a shortened, abbreviated version of their longer committee analysis, and they create the floor analysis. We used to have in the Assembly and Senate separate offices of floor analyses, and they had a separate group of consultants who did floor analyses. That's not done anymore. The policy committee does it now. So that's just a cut and paste of that. So I know that the courts, the judiciary will always say that, and at the federal level too, that a floor analysis is more valuable. Why? Because it's being considered by the legislature as a whole. So they'll go there first. That's just a shortened version of the committee analysis. Let me back there. No? Oh, yeah. Okay.
You answered why you favor the floor analysis over committee analysis, because it's okay. Why do you prefer the floor analysis over the committee analysis? And then my second question is,
because I was trying to give a little something to Kaufman.
Yeah, or is it because it reflects all of the sort of, I don't know, whatever.
Yeah, I mean, sometimes they do. Well, that's the concurrence analysis. You know, when an assembly bill has been amended in the Senate and comes back to the assembly for a final vote, a concurrence vote, or vice versa, an SB coming back from the assembly that's been amended, the concurrence analysis will note amendments made by the other house. And so those are generally pretty good, but that only deals with the amendments themselves. So if you've got like two amendments, they'll be called out. And so that's probably more insightful, but it's only on the amendments that the other house made, not all the other stuff that they approved of and that went through the assembly, for example. It's just like if you look at the Ledge Council Digest, they are required by the joint rules to amend their analysis. I'm sorry, they don't do an analysis, to amend their digest for a bill that's on concurrence. But oftentimes, like in the last week of session, when hundreds of bills are going through, they don't have the time to actually do that. So they don't have an updated digest. And sometimes the digests are good. Again, the only different, the biggest thing between the analysis and the digest is, remember, Ledge Council is required to describe what is existing law. So generally, it always starts with existing law does. And then what does this bill do in a completely independent way? No analysis, just this is what it does. So their next paragraph says what? This bill would, right? Doesn't put it into, the only context is existing law doesn't have a research and development tax credit. This bill would enact a research and development tax credit. That's all it says. It doesn't say why. It doesn't say, we do these 5 other things. It just says this. And it may mention, generically, like usually it says something like to be claimed by a qualified taxpayer as defined, for qualifying purchases as defined, because usually it's like 10 subdivisions of what is qualifying property, for example, in that type of scenario. So the digest is only partially helpful, but again, I think most insightful in terms of specific amendments is the concurrence analysis.
I just got a clarification
Okay.
question. So number 3 on your list is letters to the Daily Journal.
Yeah.
So the Daily Journal is the daily journal of the body.
Yeah.
Right? So that means all the letters were produced in the process, and then
Yeah, they're only
is-
doing, and I have a compilation. I've gone back about 20 years now. It's on the Capital Weekly website. I update it every year. There's anywhere from 12 to 20 letters per house, and most of them come in the last week of session. And again, usually they're to like maybe give some guidance to an executive branch agency or department that has to implement it, or to assuage somebody's concern, or maybe the administration has asked for amendments and they don't have time to amend it at the end of session, especially now with the 72-hour in print rule. And so they'll write like a letter to the journal and say, this is what was meant, or I'll author clarifying legislation next session, or things like that.
So that's all the letters. Like if the sponsor,
Mm-mm.
the author receives a letter.
Those are just letters to the journal by the
Oh, okay, so
author.
there's additional. Okay, I
Mm-mm.
see.
No. Those aren't like advocacy letters. No. That's the only people who are allowed to submit a letter to the journal is the author of a bill. Only the author of a bill. And I've got a whole, the courts are, I made a recommendation, particularly last year. It was not followed, but I said, look, based upon the Cal Supreme Court and how they view these, they're given some credit, if you will. The problem is that they're basically adopted en masse as they're shutting down the session. And I said, in order to comply and give greater credit, is you should distribute the letter to everybody, all the members on the floor, at the time that you are casting a vote, so that the legislature and those who are researching legislative history can say, hey, the assembly knew at the time that they were voting on this thing that here is this letter from the author that we all got that says it's my intent to do this, or here's what is not included in this bill, but they don't do it that way. And so I think that's one of the reasons why the courts don't, I mean, it's not like I ran it by the Supreme Court, but that complies with what they're concerned with. The letters come in after the fact, sometimes 2 or 3 days after the body has already voted on it. So how do you ascribe that letter as intent of the legislature when they didn't know about it at the time they voted for the bill, right? So I'd like to see them change their process.
Chris,
Yes, sir.
I'm looking at a case in Sons Kaufman, and it talks about the legislative council makes no mention of this private right of action. This is Lancaster v. Netflix.
Okay. Okay.
Legislative council, those statements important, where do we find those?
Well, the court said that, right?
No, it says the legislative council.
Yeah, but who talked about legislative council? Didn't the court do it?
Yes,
Yeah. So they're saying in the digest, they didn't mention the PRA. A digest is not exhaustive. The digest, the attorney, so the 85 attorneys at legislative council, they draft the bill. Even when private parties or legislators draft language, no bill can be introduced or amended in the legislature without it being in what's called leg council form. So even if we negotiate language word for word, you can give it to leg council and say, draft this and don't change a bloody word on it. And they'll do it that way. They're the attorneys for the legislature. But remember, they'll draft anything. You can pre-draft it and give it to them, and they'll tweak it and make sure the language is consistent, blah, blah, blah. Other legislators walk in and say, I was reading this article in the paper, or a constituent said we should do X. Can you draft me a bill to do X? And they'll draft it from scratch. That's their job. That's what they do. When they finish drafting, they write that digest. So the joint rules require every bill upon introduction to have a digest. And again, it's existing law does X, this bill would do Y. So they don't mention everything because sometimes bills are 10 pages and sometimes they're over 100. The digest is supposed to be relatively short to give the reader, the legislator, the staff, or the member of the public a quick, unbiased view of what's this bill about. It's not an exhaustive treatment. A, you got to read the bill to find out the fine print. And B, in theory, the committee analysis walks you through all the provisions. So whether a provision is called out in the digest or not is irrelevant. The digest is not part of an enacted bill. So I don't even know why a court would point to what is or is not in the digest. Once again, it's a lack of understanding about the process in the legislature, in my opinion. Okay, one more.
We have one question from the virtual participant.
Oh, okay.
Someone had asked if you could please just remind us, you talked about materials that go to the governor that we don't see, that the legislature doesn't see before they vote. Could you just remind us again what those were, I believe?
The EBR, the enrolled bill report. Yep. What is it?
Well, I think I heard you say early on that in California, you have this legislative council which drafts
Mhm.
legislation, then you have the committee staff
Yep.
separately.
Yep.
And I assume that when it's in committee, they
They
are
do an analysis.
doing the analysis.
Huh?
Okay, so long time ago, I worked in the Louisiana legislature,
Okay.
and I think the committees, those two functions were in together. The committee staff did that work as well. Like we had when the lawyers that I worked.
You mean
with-
they drafted bills?
Yeah,
Yeah.
I think if I understand correctly, I work for the environmental committee now, I draft the bill and I'm
Yeah.
working on it all the way.
Yeah, no, we don't do that.
I wanted to ask you, if this has changed over time everywhere, or if it's just.
I can't speak to any other state. At the federal level, they have a US House OLC and a Senate OLC. There's not a requirement to use them. Again, in California, you cannot introduce or amend a bill unless it's in the form as drafted by leg counsel. The whole reason, of course, is to, in theory, consistent language in the codes. And remember, those 85 attorneys, they draft in certain areas like cannabis, tax, pensions, blah, blah, blah. some of them have been there for 30+ years, and they've drafted obviously hundreds of, if not a few thousand code sections, and operate in there. And that's why they decide, for example, where they go in the code. I mean, I've had plenty of clients who have said it should go over here, and I say, that's not up to us. That's up there. Ledge Council is the keeper of the codes. They decide where new statutes go, et cetera, et cetera. So we have very separate and distinct. Now, committee consultants will often draft amendments. They'll suggest them, but they do not draft bills from scratch like the attorneys at OLC do. Yeah, you bet. Okay, well, thank you so much for having me. I appreciate it.
I just wanted to give a quick thanks to Chris for his informative speech. It was great to kind of hear the inner workings of the folks in the Capitol across the causeway. We're going to take a quick, or not a quick break. We're going to actually break until 1:45, actually 2 o'clock. So we'll check in then. Okay. Thank you.